Since we were just talking about things that we can do on the local level, um, I wanted to review a little bit about the separation of powers before we begin Article 2. So some of the biblical wisdom that our founding fathers included in the Constitution are separation of powers and sovereignty of the people. So first, because of acknowledging that people are fallen sinners, from Romans 3:23 we read, "For all have sinned and fall short of the glory of God." So because of this biblical truth, the founders knew that it was dangerous to give too much power to any one person or group. So they separated the powers, and they separated them into legislative, executive, and judicial branches. So different types of government power, they separated into different branches. But in our federal system, we also divide them at different levels, federal, state, local, and people. So, often in the news, we hear a lot about the federal powers and, federal actions and what's going on at that level. But we shouldn't ignore the state and local levels and power that the people retain to themselves. So don't neglect these maybe less publicized but still very important levels of government power. And they also limited the government power in the Bill of Rights to protect the rights of the people. So the whole point of the Constitution and the Bill of Rights is to limit the power of government so that they don't trample on our rights as people. And the kind of the flip side of all people are sinners is that people can be redeemed. From the next verse, Romans 3:24, we read, "All are justified freely by his grace through the redemption that came by Christ Jesus." So the founders trusted people to govern their own lives, and they trusted the people to have sovereign power. They thought the only legitimate place to have the sovereign power, instead of in a monarchy, the king would be the sovereign, but they gave the sovereign power to the people. However, they still don't entirely trust us since we are sinners too. So the people have no direct means to exercise power. So we can only exercise our power through elections. Okay, so now we'll go on and discuss Article 2 of the United States Constitution. So Article 1 starts out defining executive power. So the executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. So when I use brown text in the presentation, that's a direct quote from the Constitution. The black text is my own wording. So this is called the Executive Vesting Clause, which grants the President the power of a chief executive. So a chief executive, like say of a company, directs the company and runs the company. So the chief executive of our country, the president, executes or enforces the laws. So the president is in charge of, say, the Justice Department, which will prosecute people who break the law, and the FBI is a part of that, which might investigate people breaking the law. So enforcing or executing the laws is a main duty of the president. The president will also direct and remove executive officers. So it's not only the president, but he appoints his cabinet and undersecretaries because he's running the whole executive branch. So he has the power to appoint and to remove officers from that branch. He also has the power to conduct foreign affairs. The president is our spokesman to the world. He's the one who interacts with other heads of government of other countries and directs our foreign affairs. However, his powers are checked by certain checks that the Senate has, such as approving treaties and appointments. So when the president nominates a cabinet secretary, the Senate has to approve that secretary. or when the president desires to make a treaty with another country, the Senate must approve that treaty. So the president doesn't have unlimited rights. The Senate has various checks on the president's powers as well. And the founders, when they were deciding on the president or the executive power, they rejected having a council to hold executive power in favor of a unitary executive, one person, because when they were writing the Constitution, they previously had the Articles of Confederation for over 10 years, about 14 years. They had the Articles of Confederation where there was just one Congress, one body of the Congress, the Continental Congress. And they had, a whole body of people, sometimes they don't agree very easily on something, or they drag things out because it's hard to make a decision and get enough people to support it. So they felt that one person could more, avoid indecision and act speedily. And they also decided that they needed the president to be a check on Congress's power. They didn't want all power in the Congress, such as the British Parliament basically holds all the power in Britain, and the prime minister is just a member of the parliament. So here they wanted the president to be separate from the Congress and not elected by or part of the Congress. So the president is a check on congressional power. So it says the executive power shall be vested in a president. It seems straightforward, but if we compare that with a similar phrase in Article 1, which says all legislative powers herein granted shall be vested in a Congress. So because in Article 1 it says herein granted, it seems like Congress is only getting the listed powers, that if you read the rest of Article 1, it lists quite a few different powers that Congress has. So does this grant only these listed powers to Congress, but all powers beyond the enumerated powers to the president? Because it only says the executive power shall be vested in the president, but it doesn't say only those granted herein will be granted to the president. So this has been an ongoing debate. How extensive are the president's powers? Are they only things directly listed in the Constitution, or do they go beyond that? So that continues to be a debate, especially as different issues come up. There's kind of a tug of war between Congress and the president as to how much power does the president have versus Congress. Also, to what extent can a president act freely in conducting foreign affairs? For example, the Congress has the power to declare war. Okay, but then President George Washington, when Britain and France went to war, he declared America neutral. So the Neutrality Act, he said, we don't want to get involved in Britain and France's war, we're neutral. Well, if the Congress has the power to declare war, does the president have the power to declare that we're neutral? Or should that be a congressional domain? So, there's tension here. And to some extent, I think the founders didn't mind that there was tension because that's part of the checks and balances between the different branches. So some areas are not completely defined as far as where the power exactly lies, but having a struggle between branches can help us, keep each one in check. The framers also debated whether they should have single versus multiple terms. If you have a single term, you're not worried about running for re-election, but maybe running for re-election for a second term keeps you more honest so that, people will want to re-elect you. And they debated whether the president should be elected by the people or by the Congress. They ultimately decided if they're elected by the Congress, they're too beholden to Congress and wouldn't be an effective check against Congress. So they decided against that. And the question of the length of the term was up for debate. Somebody had proposed as long as 20 years. So eventually they settled on a 4-year term as long enough to have an effect, but not so long as to ruin the country. So, the whole Constitutional Convention was a lot of debate and, okay, what's going to be best? And there were a lot of compromises made along the way. but I think they reasoned out a lot of things effectively. Continuing section 1, it talks about the Electoral College. So in the Electoral College, each state has a number of electors equal to their senators and representatives. So each state is guaranteed at least one representative, regardless of how small their population is. And all states have 2 senators. So minimum, each state has at least 3 electoral votes. And larger states have more representatives and thus more electoral votes. And these electors are appointed according to the direction of the state legislature. So initially, the state legislatures would meet and appoint electors, and those electors would then elect the president. Over time, through the 1800s especially, more and more states decided to have an election to hold of the people, have the people vote for the electors rather than just the people's representatives in the state legislature. So now we've gotten to the point where people directly elect electors who then elect the president. The electors meet in each state and vote for the president and vice president on the same day. The founders wanted to have the electors meet each in their own states to make it harder for some group or to have influence over them, or for there to be intrigue, because if they met all in one place, they thought it's easier to influence one group in one place. But if they met in each of the different states, it's much harder to influence the electors. So, even down to that detail, they thought, okay, it's better that they meet in their own states than all gather in one place where they might be influenced as a whole. So a lot of thought went into making the Constitution. So the president of the Senate, who's the vice president, opens their certificates that were sent from each state and counts the votes in the Electoral College. And if no one receives a majority, then the House of Representatives will choose the president out of the top 5 that are running, with each state getting 1 vote. So even though there are multiple representatives from most states, they would decide together what their 1 vote for their state would be for the president. So the qualifications for the president, there's 3 listed in the Constitution. The first one is they're a natural born citizen, which is actually directly taken from the Bible. Deuteronomy 17:15 says, "Be sure to appoint over you a king the Lord your God chooses. He must be from among your fellow Israelites. Do not place a foreigner over you, one who is not an Israelite." So the founders, directly followed this, saying any president has to be natural born. At the time the Constitution was adopted, they said, or a citizen when this document is approved. But now we're long since approving the Constitution. So now everyone who wants to be president must be a natural born citizen, because they didn't want a foreigner to come here and try to take over by becoming president. Also, the president must be at least 35 years old and a resident of the US for at least 14 years. So they wanted someone who was born here, had lived here. They want someone who's attached and devoted to the country, and someone who's at least 35, who's more mature and has had some experience in life. So they thought it's important to have someone mature enough to do a good job and devoted enough to the country that not have divided loyalties. So therefore, they have these requirements for the president. The president is replaced by the vice president in case of death or resignation or inability to perform their duties. According to the 25th Amendment, it allows for the vice president to take over during a temporary disability. So that was a bit of a question when the 9th president, William Henry Harrison, died a month into his term. His vice president, John Tyler, became president, and it was a question: was he acting president or was he just the president with no acting or temporariness to it? So he took the view that he was the actual president and not just an acting president. So that kind of set a precedent that when the vice president took over, he became the president. So if there was a temporary disability, there was a question as to, does it go back to the original president, or does the vice president stay? So the 25th Amendment cleared that up to say that during a temporary disability, the vice president can perform the duties of the presidency, but then relinquish it back to the original president when he's able to take over again. So in the original Constitution, they would vote for vote for the president, and then whoever was the second place would become vice president. Not, they didn't have parties at first, so just first place was president, second place was vice president. But that led, the second president was John Adams, and his second place in that election was Thomas Jefferson, and they were political opponents. So you had a president and a vice president that didn't agree on a lot of things. Later, as parties developed, they decided, okay, we'll have the president and vice president run together as a ticket. And so we have separate elections in the Electoral College for president and vice president, so that you don't have two people from different parties becoming president and vice president together. So that was kind of cleared up with the 12th Amendment, because they had a tie in the election of 1800, and it was kind of a bit of an impasse. It took 36 ballots in the House of Representatives to decide to make Thomas Jefferson the president. So that led to this 12th Amendment. Also, it specifies the president's pay cannot be changed during his term in office. So that's similar to the 27th Amendment now with Congress, that their pay can't be changed until after the next election. So they wanted to make sure that people don't get into office and then jack up their pay just to make themselves rich. So the section 1 closes with the oath of office. So the oath is specified word for word in the Constitution, and only the president has an oath, spelled out word for word in the Constitution. So as he becomes president, he declares this oath: I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So it says the president's to defend the Constitution, which means, our rights and the limits on government power. It's not to take care of people. It doesn't say protect the people from all harm. It's to preserve, protect, and defend the Constitution. And that follows directly from this quote from the Declaration of Independence, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So the president's job is to preserve our rights, and by defending the Constitution. So the president isn't, the national father supposed to take care of everybody and provide everything everyone needs. That's really not the place of the president or even the entire government. It's the place of the government is to defend our rights. And often the presidents, I think most always, they will end with "So help me God" at the end of the oath, although that's not specified in the Constitution. But they're swearing before God, so that was also a thought of the founding fathers, that even if the president isn't answerable to anyone else, they're answerable to God. So that should help keep them, doing the right thing and not going astray. So Section 2 lists the presidential powers. So from Article 1, there's quite a long list of powers given to Congress. The list is much shorter for the president, which goes back to the debate. Does the president only have the powers listed, or do they have additional powers by virtue of being the chief executive? So it starts out Commander-in-Chief of the Army and Navy of the United States, as well as the state militias when they're actually serving the United States. So this is where we get the phrase Commander-in-Chief. So the president is the commander, the leader of our military. And so here again we have the Congress declares war, but the president is the commander-in-chief of the military. So there's tension between these, the president's leading the military, but can't go to war without Congress's approval. So we see the checks and balances in place here. He may require the written opinion of principal officers of executive departments on subjects pertinent to their office. So he's the boss of the executive branch. So he can ask his officers, his underlings, to prepare reports for him and help carry out how he thinks the executive branch should be run. The president also has the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. So the president can commute sentences or pardon people. Commutation is saying that, okay, the sentence you've received up till now is enough. You don't have to finish the rest of your prison term. And so you're free as of today. That's different from a pardon. A pardon completely erases the conviction. So it's as if you were never convicted, as if it never happened. Commutation just says, okay, you're done now. You don't have to serve more of your prison term. So sometimes the president might decide to commute or other times pardon a person. But except in cases of impeachment, which is a congressional power. So again, checks and balances. The president can make treaties with foreign countries, but only with the consent of 2/3 of the Senate. So in some sense, the founders developed the Senate here as a kind of executive council to check the power of the president. Here, 2/3, not even just a simple majority, but 2/3 of the Senate would have to agree to a treaty. So it makes it a fairly high bar to overcome. So there has to be good consensus that this is a good treaty to enter into. It also says, with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and councils, judges of the Supreme Court, and all other officers of the United States. So when the president is, say, appointing cabinet ministers, cabinet appointees, then the Senate will vote on whether these are appropriate assignments, appointments, and also judges to the Supreme Court and judges to lower courts. So the president has the right to appoint all these, but it's with the advice and consent, the approval of the Senate. And Congress can allow for lesser officers to be filled without their consent. So after the cabinet level secretaries, maybe the undersecretaries, lower level offices can be filled without approval of the Senate, just because they get too cumbersome, especially given that the federal government currently has millions of employees. And vacancies, when the Congress is not in session, vacancies can be filled by the president, which is called a recess appointment. So if they're not available and not in session, the president can appoint someone and they can serve until the end of the next session of Congress. So there's a limit to that appointment, but Congress can't just adjourn and say, well, you can't appoint anyone now, we're not there. So it allows for recess appointments. Section 3 talks, it's a shorter section, talks about the State of the Union and adjournment. So it says, here's where we get the State of the Union address. It says, he shall from time to time give to the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. So early on, presidents would just submit a written report to Congress. But later they started making State of the Union speeches each year, except this year. So they would go before Congress and make a speech saying how things were going in the country, and they can also recommend measures. It's up to Congress to pass any measures that the president recommends, but the president's able to recommend things if he judges them necessary and expedient. He may also, on extraordinary occasions, call Congress into session, and so that'd be a special session of Congress, and adjourn them if they disagree between the House and Senate on adjournment. He shall receive ambassadors and other public ministers. So again, this talks about the foreign affairs that the president conducts. He receives ambassadors from other countries. and he shall take care that the laws be faithfully executed. So going back to the oath, to the best of his ability, he's to preserve, protect, and defend the Constitution and make sure that the laws are carried out. So the president, the laws are passed by Congress, and it's the president who enforces them. So in some sense, they need to cooperate here in passing laws and executing or enforcing the laws. And it continues, shall commission all officers of the United States. So that touches again on the president is the one who appoints the people that fill the executive branch. He's the boss of the executive branch. And then Article 2 closes with a short section on impeachment. So it says, the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So there can be arguments and discussions on what exactly constitutes other high crimes and misdemeanors. Treason and bribery are fairly well defined, but other high crimes and misdemeanors can be open to discussion. The House can impeach on a simple majority vote, as we've recently seen, but the Senate needs a 2/3 vote to convict. So they didn't want to make it easy to remove a president. So again, a 2/3 vote, as in the case for treaties, is needed in order to convict a person to be removed after they're impeached. So the House impeaching is just bringing the charge, and then the Senate acts as kind of a jury, and it needs a 2/3 vote in order to convict. So the president also is not above the law. The president's not an absolute monarch. America had just broken away from England because they had a king that was not respecting the rights of the people. So a monarch, their word is law, but the president is subject to the laws passed by Congress, which is also a check on the president's power. When we look at Deuteronomy 17:18-20, we see when he, the king of Israel, takes the throne of his kingdom, he is to write for himself on a scroll a copy of this law taken from that of the Levitical priests. It is to be with him, and he is to read it all the days of his life, so that he may learn to revere the Lord his God and follow carefully all the words of this law and these decrees, not to consider himself better than his fellow Israelites and turn from the law to the left or the right. So taking heed of this biblical injunction, even the king of Israel or the president in America is not above the law. He's supposed to study the law, to know and not turn away from the law, and not consider himself better than the fellow citizens. So although the presidency is an important position, it doesn't set you above the law or better than your fellow citizens. So a few conclusions here. The president executes the laws or enforces, runs the executive branch, directs and removes executive officers, conducts foreign affairs, and is commander-in-chief of the military. Now, the president's the only nationwide elected official, so he can kind of be a voice for the country because he's the only one that all the people of the country have voted for, or has had an election in which he was elected by all the people. So, so he's kind of the best place to have a unified voice for the country. The president is elected independently of Congress, so they can be a check on congressional power. And also Congress has checks on the president, such as impeachment, declaration of war, approving nominees or treaties. So each one can be a check on the other, which is our federal or our constitutional system of checks and balances, so that no one person or group has complete power. So that concludes Article 2.